if you want to regulate wind and solar, there are certain rules that go along with that, and there's a statute that prescribes exactly how counties are to regulate in that section. Next slide. So let's just talk about county regulatory authority just over solar and wind energy systems together. We'll start with that. Next slide. There is a specific statute that deals with the authority of a county, and for that matter, a city, village, or town as well, in relation to what can and cannot be done in terms of local control and local regulation. First, let's talk about the definition of these systems. A solar energy system is equipment which directly converts and then transfers or stores solar energy into usable form of thermal or electrical energy. And then a wind energy system, similarly, it's equipment and associated facilities that convert and then store or transfer energy from the wind into usable forms of energy. So that's what we're talking about with both solar energy systems and wind energy systems. Next slide. 660401 is the statute that I was mentioning earlier. That's the statute that is directly applicable in dealing with local regulation of both wind and solar systems. 660401 is a limitation on county authority to act. And many of you probably recognize that there is opportunity within the statutes, and there are statutes where essentially the legislature has granted counties the authority to do something and basically left the details alone. Said simply, counties, you have the authority to enact regulations for the purpose of public health, safety, and welfare, for example. And then left the details to the county. 660401 is not one of those statutes. 660401 says counties have the ability to regulate, but if you do regulate as a county, here's what you need to do. Next slide. So when we talk about these restrictions, when we talk about the construct of 660401, really, what are we talking about? Next slide. Well, what happened is back in 2009, the legislature adopted Act 40, which was 660401. And in that process, the legislature says that a political subdivision, a county, may not place any restriction, directly or indirectly, on the installation or use of a wind energy system that is more restrictive than rules that the Public Service Commission has adopted. Okay, prior to 660401 sub 1M, a county could regulate wind energy systems as long as the regulation had a relationship to the three standards contained within statute. Now, as it relates to wind energy systems, we've said, the legislature has said, counties, you cannot regulate unless you meet these standards contained within Public Service Commission rules. Next slide. So, when we talk about regulation, first step is making sure that whatever ordinance, whatever regulations we have in place as a county meet one of the three conditions contained within statute. Number one, the restriction either serves or preserves or protects the public health or safety. Two, the restriction does not significantly increase the cost of the system or decrease its efficiency, or the restriction allows for an alternative system of comparable cost and efficiency. So in regulating either a wind or a solar facility, the first step is to make sure that the regulation that is being imposed satisfies one of these three standards. Next slide. So we're not permitted as counties just to make general policies applicable to all solar and wind energy systems. When we think about, for example, a zoning code, it is one size fits all. The zoning code applies everywhere. Now, there are elements of the zoning code, and there are similarities, obviously, between the zoning code and what we're doing with regulation of wind and solar systems, in that there are case-by-case determinations, and in zoning parlance, we call that conditional use permits and variances. When we get into conditional use permit applications, we get into variance applications. That is a case-by-case determination based upon the particular facts and circumstances presented by a property owner to the zoning committee or to the county board or to the Board of Adjustment. So in this circumstance, we're dealing with a very, very similar situation here, in that the Ecker Brothers versus County case tells us that we cannot make these regulations applicable just to everybody in terms of our authority to regulate. We have to hear the specifics of a particular system and then decide whether a restriction is warranted. All right. So as you'll hear Rebecca talk about and Ben talk about later, we're really talking about a CUP process when it comes down to regulating a wind or solar energy system. And when we talk about a CUP process, that of course brings in a whole new set of issues for counties in their deliberative process of whether to approve the conditional use permit, and then how do we monitor that CUP to make sure that it proceeds according to what the conditions are contained within that CUP. In addition, and we'll touch upon this a bit later, you've got the Act 67 standards that come into play. And some of you probably recall that Act 67 created a provision within the statutes detailing how it is that counties, when they're going to adopt a conditional use permit process, what it is that they need to consider. So we'll get into that a bit later. Next. So we can't prohibit or restrict any person from conducting testing activities. We know that. Testing activities include tests performed to determine whether a site's suitable for placement of a wind energy system. This inability to restrict or prohibit testing does not apply to solar. It applies only to wind systems. You can petition the Public Service Commission to impose reasonable restrictions on testing activity, again, on a case-by-case basis. Next. So I'm going to turn it over. I think that, is this Ben or Rebecca that's going to talk about wind systems? Ben's going to
That's me for this one.
Ben is more of a windmill guy. Rebecca is more sunny sunshine. So we're going to let Ben, what is it, the hot air guy? Is that what we're calling you now, Ben?
Sure.
Okay, the hot air guy. Ben, take it away with wind systems. Thanks.
So as Andy mentioned, in addition to those 3 criteria set forth in statute, that 2009 Act 40 also imposed a uniform set of procedures for wind energy systems specifically. And when we're talking about, the wind energy systems, it has to be also in compliance with that PSC rule that Andy mentioned, Chapter 128 in the PSC code, which so it kind of goes hand in hand with the statutory procedures. But the statute sets like the broad guidance and standards that have to be met first, and then there's also the more detailed provided in the PSC rule. So today we're going to go through the statutory process, touch a little bit on the PSC rule, but not in great detail. Again, just for it's kind of outside the scope of this presentation, and for timing reasons, that rule goes into a lot of detail. So again, counties have the ability to enact an ordinance to regulate the wind energy approval process. They do not have to, though. It is optional. That does kind of trigger 2 different paths that are followed once an application is followed or filed, though. So we'll go through both those processes here in a second. So the first situation is when a county does have an ordinance in place. If an applicant files an application for approval of a wind energy system, or the construction and operation of a wind energy system, the county first needs to make a determination whether that application is complete. So once an application is received, the county has 45 days to notify the applicant whether the application is complete or if there's additional information that's missing. Either way, once the application is filed, the county must publish a Class 1 notice to give public notice that this project is being proposed. If the county's going to hold any public hearings or that sort of thing, when those might happen. Again, and then if the county determines that the application is incomplete, it must notify the applicant why it's incomplete. At that point, the applicant can choose to supplement the application or refile entirely. Either way, there's no limit in the number of times that the applicant may either refile or supplement the application to kickstart that process again. If the county doesn't make its determination within 45 days, the application is deemed to be complete, and the rest of the process then kicks off. As you'll see in this approval process, basically anytime it's wind friendly, I guess I would say, in terms of if the county doesn't meet its deadlines, you know, applications are deemed complete or approved, that sort of thing. That's kind of the consistent theme throughout this process. If a county does not have a wind regulatory ordinance in effect, that 45-day time period for determining whether an application is complete doesn't begin until the first day of the fourth month after the county receives the application. So the intent here is for counties that don't have an ordinance is to give them time to consider, draft, enact an ordinance if they choose to and they want to regulate wind energy systems. You know, a good example is if there's a county that's never had one of these projects before, may not have had a reason to have an ordinance in place. But you know, if as these projects become possibly more popular or start popping up in different areas of the state, the idea is to give counties the opportunity to put the ordinance in place and regulate those systems if they choose. On the flip side, if the county doesn't want to regulate that and leave it to the PSC code, part of the PSC code still applies whether the county has an ordinance in place or not. Some of it doesn't. But either way, if the county decides it doesn't want to be involved in the regulation of that wind energy system application or approval process, at any time the county can notify the applicant that they're not going to enact an ordinance, and at that point the application is deemed complete, and all the applicant needs to do is comply with the relevant PSC regulations. Another public notice requirement, that's another common theme throughout these statutes, is there's a lot of public notice requirements, both on, again, the county when it receives the application, as I mentioned, has to provide that class 1 notice, but the applicant must also mail and deliver written notice of the application to the owners of adjoining land to the project site. The statute does also specifically state that applicants may make minor modifications or supplements to that application without triggering the need for you know, another public notice. The idea is that they give the landowners notice that this project is, you know, in the works and might happen. But if a supplement is required to that application, it doesn't mean they have to restart that notice process. Again, this is set forth in statute. This would be best practice anyway, but is required in this case. In going through this process, the county needs to keep a record of its decision. The statute specifically requires recording any public hearings, keeping a record of copies of documents submitted at a public hearing, any other documents submitted in connection with the application. There's also more detail again provided in that PSC chapter 128. You know, again, this is best practice anyway. As we're going to go see as we go through here with how the decision is made and any restrictions, denials, approvals that happen, it's really important that they're backed up by a written record and evidence to support those decisions. So then as we go forward, now we've had the application, the notices, you know, any public hearings, review the evidence and establishing of the record. Then we get to the actual decision process. So any decision made by a county on an application for approval of these wind energy systems, again, must be based on written findings of fact supported by the evidence in the record. So again, that record is really important. Keep a lot of detail in all relevant documents. You know, as we go forward, any of these decisions can be appealed to PSC. So as PSC looks at it, they're going to be looking for, well, is this restriction or denial by a county actually supported by the evidence? So again, really important to keep those detailed records. Again, there's more detail in how this process is handled by in the PSC code. And this process needs to be completed within 90 days of the time the county deems the application to be complete. So once the county says application is complete, gives that notice to the applicant. County has 90 days to review the record, request any more information, and decide whether the application should be approved, disapproved, or any reasonable restrictions placed on that approval. Again, similar to the application completion process, if the county does not act or make its determination within that 90 days, the application is deemed approved. There are some exceptions to that where the county can extend that deadline. There's 3 reasons given here, and some different amounts of times that or time that the process can be extended, but in total it can only be an extra 90 days. So those reasons are if the county needs additional information to make its determination, the county can extend the deadline by up to 45 days. If the applicant makes a material modification to the application during this process, 90 days can be added to that deadline. And again, if there's some other good cause specified in writing by the county, but even if it's one of those reasons or a combination of the 3, the total extension cannot exceed 90 days. So then again, in statute, there's specific limitations on reasons for denial and restrictions. Again, this kind of goes back to the PSC rule. There's a lot of detail in the PSC rule, but the overarching theme is that any restrictions or denials on these applications need to be reasonable and kind of conform again to those standards that Andy discussed earlier. So this is why, again, it's really important to keep that detailed record and have good, strong evidence supporting why these decisions are made. If a decision is appealed to PSC, again, there needs to be a robust set of written evidence supporting why that decision was made. Again, these regulations are in favor of wind and solar energy and restrict the county's ability to regulate those systems. So any restriction that is actually placed or on these systems or a denial really needs to be supported by robust evidence. Now, I guess another reason for denial that's kind of separate from all that, that's specifically set forth in statute, is if there is an area that the county has primarily designated for future residential or commercial development in a comprehensive plan, that in and of itself can be a reason for denial of a wind energy system. Now that plan has to be either adopted before June 2nd, 2009, or if the map has been updated as required in statute after December 31, 2015. As I mentioned, these decisions can be appealed by the applicant to, so any adverse decision against the applicant can be appealed. There's a couple options for the applicant to follow. The first is to appeal use the county's administrative review process. Kind of the simplest, but probably most efficient first step. And then if the county's review process concludes and that decision stays the same, not changed, the person may then file an appeal with the PSC within 30 days of the conclusion of that process. If the county doesn't conclude that process within 90 days of the initiation by the applicant, then it's deemed to be completed, and then triggering the applicant's ability to appeal directly to PSC. Although alternatively, the applicant may actually just appeal directly to PSC instead of going through that administrative review process. I think the reason for the different options here is, in an efficiency standpoint, if it's something minor and the applicant feels they might be able to just work with the county and get it done through that process, then they may choose that. If they don't see that as an option or a viable option, they may appeal directly to PSC. That's kind of a big step because it's there's more, they're going to have to sink more time and resources into that, and it's probably going to take longer. But that is an option. But that has to be filed within 30 days of the county's decision. Also, an applicant may appeal directly to PSC if their application is denied, for the reason the separate reason statute I mentioned, which is for that comprehensive plan designating the area as future residential or commercial development. The PSC can actually take that up and decide whether it's a reasonable denial still or not. So that was kind of the wind energy specific statutory regulatory process. Again, the intent of that 2009 Act 40 was to set a standard process throughout the state, and require that counties all follow that process, so that applicants kind of have a sense of what to expect throughout the state.
Ben, before we move on, we have a couple of questions that I think impact things you just discussed. Why don't we take a moment and go through a couple of these questions? First question we had, I think this is a great question, and this just shows how different statutes can impact different things. Question was whether the section 66.10015, which is the new section following 2013 Act 74, which some of you might recall placed restrictions on the ability of a political subdivision, municipality, county, from imposing certain regulations on building construction and things like that. Do the limitations and the timelines in 66.10015 apply in equal force to an application for a wind energy system or a solar energy system? And that comes down to the question of whether the limitations in 6.10015, and in this case, the question about whether there is a 10-day limitation on the period of time a county is able to review an application for a wind energy system. Do those limitations apply to an application under 66.0401 for constructing a wind energy system? I've not dealt with that question before, so full disclosure, I've not researched it, but just in looking at the statute and how 0401 works and 10015 works, I don't think it does, because there is an entire section of the statutes in 0401 that deals with what they call wind energy systems and solar energy systems. The word system isn't in 66.10015, even though that language in the statute is very broad. So it would be my impression that the process and the limitations contained in 0401 exist separate and distinct from the process and limitations in 10015, and the process under 0401 is self-contained. In other words, if you have an application for a solar or a wind system, you follow the prescribed procedure in 0401 and the PSC rules as opposed to the 10015 rules. I don't know if Rebecca or Ben, you have any additional thoughts on that?
Nope.
Okay. Second question, there was another question in here dealing with solar systems, and I'm going to leave that for Rebecca when she goes through that process. But next question, do you have to notify neighbors at the time of application and for notice of public hearing, or can one notice of a public hearing suffice? Ben, do you know the answer to that one?
So I think there's two things going on here. So when the application is filed, the county needs to publish a general class 1 notice that the application has been filed. I guess I would think if the county has already scheduled a public hearing, they could include that information in the same notice. But regardless, the county needs to publish a class 1 notice when the application is filed. The applicant, when the applicant files the application, also needs to provide written notice to the adjoining landowners. So there's both a notice requirement on the county and on the applicant.
Got it. Next, we have a question about, and this is a good point here, given that a county cannot deny a wind project approved by the Public Service Commission unless the project is proposed to exist in an area mapped for commercial or residential development in the comp plan, what benefits are there to a county imposing PSC standards? Because after all, it seems to be a false assurance to the public that there is, in fact, local decision-making authority as it relates to the project when In fact, application of the PSC standards are not local decision-making, it's PSC decision-making. And I think that's a good point, and that's where we get into all sorts of questions about whether a particular limitation or restriction contained within a local regulation, in this case a county ordinance, is it really different than the PSC standards? And if so, do we have the ability as a county to impose those types of standards? And as we know from the Ecker Brothers case, it has to be on a case-by-case basis. We can have those standards contained within ordinance, but application of those standards to a particular project is going to be case-by-case. And so when we're looking at building out our local code as it relates to regulation of these projects, especially the wind projects, which are highly, highly regulated by PSC, the question becomes, is there any value to incorporating PSC standards within county ordinance? And I guess I can see merits on both sides of the equation. Part of me says that it would be good to have those standards contained within ordinance, or at least reference to those standards, because again, those standards may change by administrative rule, and we don't want to have our ordinances inconsistent and out of date with the PSC rules. Part of me says that might be a good idea to provide the public with notice as to the entire process for application and approval and the standards that will be imposed by PSC. And then there's another part of me that says it's a state law matter, and so let's let the state agency enforce state law. So I can see a little bit of argument on both sides of this. Rebecca or Ben, do you have any thoughts on that?
Well, I think the other thing to consider too is that in the PSC Chapter 128 regulations, there are some that apply if the county doesn't have an ordinance, but there's some of that chapter does not apply if the county doesn't have an ordinance. So if the county isn't regulating, there's, I guess, less rules and restrictions applicable to some of these projects, if that makes sense. There's part of 128 that applies regardless, and part of it that only applies if the county is actively regulating.
So in other words, if a county wants to take full advantage, for example, of the PSC regulatory process, then it needs to have an ordinance on the books that would trigger those additional limitations contained within the administrative code. Is that right?
Correct.
Okay. We have another question. Do we have any actual examples of a county regulation impacting an application for a wind energy system? I don't off the top of my head, and I know that, I mean, I've talked with several counties that are going through the process of wind energy siting systems and what the extent of a county authority is, but I don't have any actual examples of just here it is where we've got a county regulation that says X that is wholly separate and apart from what the PSC regulations say, and that X is going to impact the application. I can't think of any off the top of my head. Perhaps other participants in the workshop have some examples, but I don't have any off the top of my head. Rebecca or Ben, do you have any?
No, I don't.
No.
Okay. Another question, is there a definition of a material modification which would trigger an additional 90-day review process? Ben, is material modification defined in the PSC rules?
I believe it is, but I would have to check to be certain. The PSC rules set forth a lot more detail. So I think they would at least give some guidance on what that means.
Okay. Next question, is it possible to receive a copy of the slides for the presentation? Yes, this will be posted to the WCA's website, and yes, we will absolutely consider that for future presentations. So with that, I'll turn it back to you, Ben, to start going through the next part of the presentation.
Yeah, and I'm actually going to turn it over to Rebecca here. This next part, before we were talking about restrictive authority, the statute's putting restrictions on what the county can do to regulate. This next part is more in the permissive authority bucket, because it actually allows counties to promote renewable energy systems to an extent. So with that, I'll turn over to you, Rebecca.
Thank you. Next slide, please. Can you flip, Ben? Thank you. As Ben indicated, the last section that we talked about was more restrictive in nature. What we're going to talk about now is deemed permissive in nature, but keep in mind The counties can only act to the extent that the statutes grant them authority. So we're still, keep in mind, we're still talking within the realm of what restrictions can the county impose. So for the, when we're talking about permissive regulations for solar and wind siting, the county can choose to enact policies to promote the siting of the renewable energy systems within its jurisdiction by enacting an ordinance. And that again goes to the specific statutory requirement that a county cannot act unless it has adopted an ordinance. An ordinance, interestingly, can provide for a greater ability to maintain your site, particularly with respect to cost of trimming. Obviously, trimming and maintenance of a site around these facilities is going to be very important, because if you can't maintain, any sort of natural landscape features or other items that might interfere with these systems, that's going to be, cause essentially damages. And we're going to talk about that a little bit more when we're talking about impermissible interference. So the trimming and vegetation maintenance is, again, it's specifically addressed in the statute. So when you're developing your ordinance, you want to pay particular close attention to those provisions. Next slide, please. So what can counties specifically do under the statutes? Fortunately for counties, under 66.0403, a county can choose to adopt an ordinance for solar and wind access permits. Now, when some of us think of access permits, you think of road access, how to get from one road to another. In this situation, access is to specifically the preservation of access to sunlight and to wind. So a person who is going to develop these facilities wants to make sure that they are not going to be interfered with. And so a county can specifically adopt this permit process to ensure that the permit holder is going to have access to their sunlight and wind resources. Now, there are some restrictions on what the permit may not do. It may only affect the land except which at the time the permit is granted is within the territorial limits of the count or of the jurisdiction. So that's something that, when we're talking about extraterritorial jurisdiction may become an issue. A county board can also appoint itself as the agency to process an application or create another agency to grant the permits. So generally, these are oftentimes going to fall within the approval procedures of a planning commission or a land use commission or a land committee, something of that nature, or a committee of that nature. Next slide, please. The county board can impose a fee to cover costs of processing applications. The fee has to be prescribed in the ordinance. However, many counties elect to adopt fee schedules, usually as part of their annual budget. So you can, if you need to modify a fee, you can do that as part of a fee schedule, so you don't have to exactly change the entire ordinance. And then the ordinance may also consider may contain other provisions that the county board deems necessary for granting the access permit, including specifying the standards for permit approvals. Now, keep in mind that even though this is more of a broad definition, as Andy mentioned before, they still have to be the approval standards, or the approval standards in the ordinance should still be specific enough that they're not just a general police power standard. They have to be not only to comply with the statutory requirements for solar and wind, but then also, as we're going to talk about, if you're granting any sort of approval based on a conditional use permit, we have to comply with Act 67 and those requirements in 5969(5)(e). Next slide, thank you. The county for access permits is responsible for the application process. And just like under the other permits we discussed, the county gets to determine whether the application is complete. And then the county must provide notice to the applicant once that application is deemed complete. And the applicant has to make sure that they submit a copy of the signed receipt from every property owner to whom notice is delivered to the agency. Next slide. The agency has to supply the property owner the notice form that owner is going to provide. The other requirements on the form can include basic elements like name and address, the address of where the facility is going to be located, and then more specific items such as how that permit, if granted, is going to affect the rights of other notified owners of their rights to use their property or to plant vegetation, because keep in mind there can't be vegetation that impermissibly interferes with the solar or wind facilities, hence the need for an access permit. Any person may request a hearing within 30 days after receipt of the notice. And then the ordinance should also address, obviously, the process for filing that hearing request. Next slide, please. The hearing is particularly important in this statute because, again, it grants a broad authority for somebody to request a hearing, usually under many zoning codes or other regulatory oversight on a county's behalf. A member of the public can't just request a public hearing. Now, oftentimes there's a public hearing that's going to be conducted anyway. But the fact that this statute allows somebody to request a hearing is unique. So any person receiving that notice, again, can request that hearing on the grant of the permit within 30 days. The county on its own may also determine whether a hearing is necessary, even if another property owner doesn't require a request for a hearing. The hearing has to be conducted within 90 days after the last notice is delivered. Like the other statutes that we've talked about, the county has to make sure that it sticks to the time frame and the right process in order to keep the application moving, and there's no unreasonable delay. And then finally, the agency must notify the applicant and all persons receiving that notice at least 30 days prior to the hearing. Obviously, that's important for notice for both people who are going to be attending and for the applicant. Next slide. Similar to the other statutes we've talked about today, the county is required to grant a permit if it determines one of three items. The granting of the permit will not unreasonably interfere with the orderly land use and development plans of the county. No person has demonstrated that he or she has present plans to build a structure that would create an impermissible interference, again, with the wind or solar facilities. And the benefits to the applicant and the public will exceed any burdens. Again, this is a differential approval in essence, because if the county makes any of these determinations, it has to grant that access permit. The third element, the benefits to the applicant and public, it will exceed any burdens. That is most likely the broadest element or the basis upon which the application can be approved. And that number three really allows the county to use its discretion in a more robust manner than it could under other statutes such as this. However, the county has to make sure that you still develop that your record to support and to demonstrate all of those benefits that are going to exceed any burden. So even though point number 3 allows a county the use of greater discretion, you still want to make sure that you have a robust record. And then finally, any person aggrieved by that determination may appeal to the circuit court for review. Again, that any person aggrieved obviously is not just the applicant, but can be a property owner or any other person who can establish that they are aggrieved by the decision. Next slide, please. The permit conditions. So we're county's looking at granting an access permit. What conditions can it place on those on that permit? Again, there's the deference to the granting of the permit, and it can contain any condition or exception that the county deems necessary to minimize the possibility of future development or nearby property will create an impermissible interference. So again, looking at an assumption of approval, and any condition has to be deemed necessary to minimize those possibilities of interference. The conditions and exceptions may include restrictions on the locations of the collector, the solar collector, or the wind energy system, i.e. the actual facilities that are collecting those resources, and the requirements for the compensation of permits of persons affected by the granting of the permit. That's another very unique element of this statute versus other land use and siting regulations, is that an ordinance can specifically set forth the compensation of persons who may be affected by the granting of the permit. So for example, if there is an unreasonable, or I'm sorry, impermissible interference with your facility under your access permit, you may seek compensation for, or there's a liability for any loss due to impermissible interference. That's a very unique, again, provision in a statute that allows for somebody to recover losses due to interference with the rights under a permit. Next slide, please. If the county grants that permit, it must also specify the property restricted by the permit, i.e. make sure that it's very specific on which properties are going to be, their rights may be restricted by that access permit. The notice has to include certain required identifications for the permit and for the owner and the property on which the facility is going to be located, and for any owner restricted by the permit. And the notice must also indicate that the property may not be developed, and again, those restrictions on the vegetation, so as to not create those impermissible interferences with the facilities. Next slide, please. The applicant must then record with the Register of Deeds in the county, obviously, in which the facility is located, the notice for each property receiving the notice of application, and the property upon which the facility is going to be or is located. Now, the importance of this step is to memorialize in a property's chain of title the restrictions on the rights to use that property. Again, whether it's the property upon which the facility is located, or on another, most likely an adjoining property or another property that is restricted by the rights set forth in the access permit. A buyer of property may not have an understanding or have a background on what rights of use are restricted based on that access permit. So the requirement that the record be recorded in the Register of Deeds ensures that notice of the access permit is granted to any potential property owner or any other entity that is going to attempt to take an interest, such as a bank or other lender, that there is this restriction on the property's chain of title. Remedies for impermissible interference. This is the unique element that I mentioned before of this statute that we don't usually see in other statutes. So any person who uses the property which he or she owns or permits any other person to use that property that creates an impermissible interference under a permit that has already been granted is liable to the permit holder or applicant for damages. Well, what exactly does that mean? What are damages and how are they compensated? Statute tells us in the next section. Damages include any loss due to that impermissible interference, court costs, and reasonable attorney's fees, with the exception of if the building permit was applied for prior to the receipt of the application notice, or the agency determined not to grant a permit after a hearing, or a permit affecting the property is terminated, or the agreement affecting the property is filed. The important element, one of the most important elements in this under this provision is that if a permit, an access permit, is terminated for whatever reason, then an owner or somebody claiming damages for impermissible interference cannot legitimately make that claim. And that's an important perspective for the county, because the county obviously is monitoring whether the reasonable and necessary elements of conditions of that permit are being adhered to. Next slide, please. Some additional points on remedies for that impermissible interference. The access permit holder is entitled to an injunction to require the trimming of that vegetation that would create that impermissible interference. Again, for adjoining or other property owners, it's very important to understand what you can and can't do with your property. And if there is that an actual impermissible interference or a potential impermissible interference, the permit holder can get an injunction. Or if the court finds on behalf of a permit holder that permit holder is entitled to a permanent injunction, damages, court costs, and reasonable attorney's fees. That's another extraordinary remedy that we don't usually see in local regulatory statutes and applicable ordinances. Next slide. Termination of rights. Obviously, the rights that a permit holder has in an access permit are significant. So what rights do they have to ensure that permit is not terminated? Any right protected by a permit granted under 660403 is terminated if the agency makes the determination that the solar collector or wind energy system, which is the subject of the permit, is either permanently removed or not used for 2 consecutive years, or it is not installed or functioning 2 years after the date of the issuance of the permit. These are important points, really from multiple perspectives, but more so from a county's perspective. Once an access permit is granted, it's not a ongoing holding of a right. That facility has to be not only installed, but functioning within 2 years. So that's something that also requires county monitoring and county oversight to make sure that these facilities are installed and functioning. The agency must also provide the permit holder written notice and an opportunity for a hearing if there is a proposed termination. And again, that it makes sense given the extraordinary rights that a permit holder has in an access permit, that if the county is potentially going to be terminating that permit, that written notice is given and the option for a hearing is provided. If the termination does occur, the agency may charge the permit holder for the cost of recording and the actual recording of that notice of termination with the Register of Deeds. Again, this is an important point because the notice of the permit has to be recorded in the Register of Deeds office to make sure it provides proper notice to both, an owner or a party seeking an interest in that land from the owner, or notice to adjacent owners. So if that permit is terminated, you also want to make sure that the chain of title reflects that termination, and therefore that the rights set forth in the permit are no longer applicable to a property's chain of title. Next slide, please. All of the rights set forth in the permit are obviously are very extraordinary for that permit holder. So there is the opportunity to waive certain rights by an agreement. So what this essentially results in is a waiver of those extraordinary rights by the permit holder. So the permit holder can waive all of those rights protected by that access permit. However, that waiver must be in writing. It has to you obviously make sure that it's specific enough that it sets forth what rights are being waived and the circumstances, and I would include the background and all of those other material elements upon which led to the decision to waive. And then a copy of that agreement has to be recorded with the Register of Deeds. Again, to provide both the someone obtaining to or attempting to obtain an interest in the property itself that the facilities are located on, but then also adjoining property owners to make sure that everyone is on notice that the rights under the permit are impacted potentially by this waiver. Next slide. So what are some important caveats in granting these access permits? Number one, a county cannot require an owner to obtain a permit prior to installing a solar collector or wind energy systems. Rather, the permit is to benefit the property owners and intended to promote investment in the solar wind facilities. So the facilities actually have to be installed prior to the granting of the access permit. And that's an element from a timing standpoint, obviously. Number two, the acquisition of a renewable energy resource easement granted under WSTAT 700.35 is not contingent upon the granting of a solar or wind access permit. Next slide, please. That's it for.
Okay, I think we have a few questions that we'll try in the next few minutes here. First, we have a question about the applicability of village ordinances, and the question relates to the county establishing its own solar grid in conjunction with a third party. Village has its own zoning ordinances and enforcement agency. How much does the county need to notify the village of what's happening? And I think that depends upon where the solar array is proposed to be located. If it's on county property outside of village boundaries, there's nothing that's required. But if it's a matter of establishing the solar array on county property contained within the village limits, it's subject to village zoning. And Ben, I think you did actually some work on that issue, if I remember right, dealing with county-owned land within the incorporated area of, in this case, it was a city, but the city requirements still apply. And in this instance, the village requirements would apply. Is that right?
Yeah, there are some general exceptions to that. Sometimes county buildings and property are not subject to village or city zoning, but generally they are. And I think in this instance, it would be subject to village or city zoning for installation of solar panels.
All right, next we have a question about whether a county can require a reasonable perimeter setback for solar equipment and plantings or screening of sites if the proposed project is immediately adjacent to residential areas. Obviously, the screening cannot affect the mechanics of the solar system. And before I let Rebecca chime in, it goes back to 660401 in the three areas where a county is able to regulate. Mm-hmm. We've got a regulation that deals with topics surrounding, let me see the actual verbiage here. Seeking to preserve or protect public health or safety. If the proposed regulation fits within that definition, then a county has the ability to regulate. But remember too that the other two exceptions on the prohibition of regulation relate to significantly increasing the cost of the system or decreasing its efficiency, and whether the regulation allows for an alternate system of comparable cost and efficiency. So I think the answer to that question is potentially you can regulate if you have perimeter setbacks, and those perimeter setbacks relate to preservation or protection of public health and safety, then you have the ability to regulate. Rebecca, any other thoughts?
No, I think you captured it perfectly, Andy. So long as, excuse me, the regulation is related to those or falls under those statutory exceptions, they're permissible. However, when you're developing your ordinance or when applying the ordinance, just make sure that it is specific enough still to pass muster under those statutory exceptions.
Next, can a county require surety bonds for the removal of equipment once operations cease? And there's an entire section within the Public Service Commission, Chapter 128 in the Administrative Code that deals with financial assurance for the owner of those systems. And so can you require a surety bond? Essentially, there are all sorts of different financial assurance mechanisms that are available. And I think you have to look at PSC 128 because the costs associated with the assurance have to be reasonable in relation to the anticipated amount necessary to remove the equipment. But an owner of these systems is required to provide adequate financial assurance to decommission, if you will, the system once the system has reached its useful life. Any other thoughts, Ben?
No, that's exactly right. And to your point, there's a few options that the owner has to provide that assurance, one of which would be a bond, but there's a couple other options that it's at the owner's option, the method that is used.
Mm-hmm. My only other point would be that to make sure that the financial assurance requirement is obviously reasonably related to those actual costs. I know it may be tempting to set it at, say $2 million. Good round number, sounds good on paper, will probably make adjoining property owners happy if they're not in full support of this facility. But again, it can't be an arbitrary set number. It has to be related to the actual costs of the decommissioning or the other elements that you're trying to make sure are paid and protected.
So the next question asks about the ability of a town to have its own local wind and solar ordinance. Well, a town has the authority, and depending upon whether the town has exercised village powers to adopt its own zoning code, that's going to be the question. If you look at 660401, it indicates a county ordinance applies only in the unincorporated areas of the county. And if a town has an existing ordinance dealing with the regulation of wind and solar systems, that the county ordinance does not trump the town ordinance unless or until the town's ordinance is modified or eliminated to make the restrictions less restrictive than the county's ordinance, in which case the county's ordinance then takes effect. And so it's like a typical zoning analysis here where we've got county zoning in the unincorporated areas and the town has the ability to elect village powers and then have its own zoning code. It's a very similar process.
Mm-hmm.
I want to ask this question because I think it's a great question. Given everything that we've talked about here this morning, what are the benefits to a county having an ordinance as it relates to solar and wind access permits? It seems like a lot of effort with no real impact as to what's being applied. And I'll direct you to PSC 128.10 because that provision of the administrative code lays out what requirements within the administrative code apply in the absence of a county ordinance and what restrictions apply if a county ordinance exists. And so if you have, as a county, no interest in regulating the variety of areas within 128 that are applicable only if a county ordinance is in effect, no need for an ordinance. If, however, you have an interest in restricting placement, dealing with coordination with existing property uses, siting criteria, noise criteria, things like that. If you have an interest in regulating in those areas, which again apply only if we have a county ordinance on the books, then you better have an ordinance on the books. Ben or Rebecca, any other thoughts on that?
No.
All right, next question. If the county does not have an ordinance, does the application get approved by the PSC? And if so, is a public hearing required? And again, I'll give you my take on it before Ben and Rebecca jump in here. Under section 193.491 of the statutes, there's an entire process for Public Service Commission review of these permits for a wind energy system or a solar system. And within that statute, there is an entire process that the PSC follows. I've not looked at this statute as it relates to the public hearing requirements, and so I don't know if there is a public hearing requirement. I believe there is, but don't quote me on that because I don't know exactly that there is a requirement. Ben or Rebecca, do you guys have any thoughts?
No, I mean, that sounds right. I'm not sure offhand if there is a public hearing requirement under the PSC chapter or section or not.
It would seem to me that if you go to PSC's website, you should be able to find out what the process is for approval of those permit applications, because again, we don't represent the PSC and are not involved in the PSC application process, but take a look at their website and that'll probably get you to the appropriate statute to determine public hearing requirements. Next question. Can a zoning permit be issued for a singular solar array system or wind turbine on a property if a singular solar array system or wind turbine is determined to be an accessory structure? I imagine the determination about accessory structure would be made under county code. That is not something, at least that I'm aware, that is defined in state statutes or administrative code. The way the statute, the administrative code divides out the systems is between small and large. And so if it's an accessory structure under county code, do you still have the ability to regulate? And my short answer is yes, depending again upon what it is that you want to regulate and PSC 128's ability to allow you to regulate, and as well whether it's a small system or large system. Additional thoughts, Ben or Rebecca? All right, when holding a hearing on a CUP, is the county obligated to allow non-county residents to speak to the matter of the CUP? Can you designate certain expert testimony from outside the county while limiting people for out of county and out of state? Okay, this gets into a question that's more a zoning question than it is anything else, and it has to do with the public hearing component under the zoning code and the required public hearing component. As we know, for example, we have a public hearing process here as it relates to approval of these permit applications, but we also have a public hearing process as it relates to, for example, a petition to rezone property. And so the question is whether we can limit the people who are allowed to testify at a hearing in relation to a petition to rezone. I believe that that is advisable, but you may not want to do that for a variety of reasons, depending upon how many people from outside of the particular area want to testify. I don't know that the burdens imposed outweigh the benefits of having that type of a restriction on the hearing. I know that in certain circumstances, individuals, property owners have their own consultants and their own engineers and others who testify either in support or opposition to a particular application. And in many, many circumstances, those consultants or engineers or architects are not from the county. And so if we were to limit the ability of out-of-county persons to testify at a public hearing, we'd be limiting the ability to get information to the particular committee or board that is going to make the decision. And as soon as you start making exceptions to a very broad general rule, of course, you run into certain concerns from a legal and a practical standpoint. And so I don't know that there is an absolute prohibition on that type of rule, but I think that there are many, many practical reasons that suggest you should think very hard about whether you want to have that type of rule on the books. Rebecca, have you ever dealt with a situation like that?
Not on the restriction of not allowing residents outside of the county to speak. You know, obviously counties adopt or may adopt other restrictions on public comment, you know, such as a time restriction or, you know, restricting comments to be limited to items on an agenda. So other reasonable restrictions like that. But I totally agree with you, Andy, that, you know, when it's a benefit versus burden, if you have those other, you know, reasonable restrictions like time element or the, you know, limiting to items on the agenda, I think you can keep control of those hearings without having that, restriction and limiting to just people from within the county.
Here's a good question. We talked earlier about the intersection between county-owned property and a village or city's ability to zone and have those zoning restrictions applicable to county-owned property within the city or village limits. What about a town? Let's say a town has its own zoning ordinance and a county wants to put a solar farm on that county-owned property that's located within the town. Can the town impose its obligations? And that raises a very interesting question. In the absence of any other consideration, I think Ben's earlier answer about likely yes is applicable, but you also have to remember that there's a provision within 59.69 of the statutes, which it's 59.69 sub 9, I believe it is. Sub 9, where it speaks to the ability of a county to rezone property that is owned by the county without first obtaining approval from the town boards from the town in which the lands are situated. And so you have certain authorities as a county on county-owned land that is located within a town that do not otherwise exist if that property is located within the jurisdictional boundaries of a city or a village. So keep that in mind. Now, we're getting into rather detailed questions surrounding the interplay between county and town zoning and county-owned property. And so really talk with Corporation Counsel before you take any action. But the takeaway from this discussion is simply a county has more rights as it relates to county-owned property that is located within town as opposed to a city or a village. Now let's take a look here. For a project that requires PSC approval, like a 150 megawatt solar project, does the county have any jurisdiction to review the application for that project? In this circumstance, we're told that Corporation Counsel has opined that 100 plus megawatt projects preempt local authority. In other words, it would be just PSC that would review that project. Ben or Rebecca, any thoughts on that?
No, I mean, other than if there is other elements that would trigger county jurisdiction, such as elements of a zoning ordinance or other permissible county ordinances, no, I think that falls to the exclusive jurisdiction would fall to PSC.
Okay, so in other words, there may be elements of the project that would require county approval, but the application for the project in and of itself, dealing with a 150 megawatt system, that's a PSC issue, not a county issue. Is that right?
Correct.
Okay. And then finally, we have a question where one of the attendees is confused about the last bit, and this question was typed 11 minutes ago, so I'm not sure what the last bit is. But apparently we discussed how an access permit cannot be required before a facility is built. This seems problematic. What do we discuss as it relates to access permits, Rebecca?
What did we discuss in terms of access permits?
Yes.
Well, I mean, essentially, the county cannot require the owner to obtain an access permit prior to the installation. So essentially the rationale is that if you are getting an access permit for your facilities, you can't get that access permit until the facility is installed.
So it's more of a timing issue as to sequence on getting the access permits and also getting permission to build a facility. Is that right?
Right. And keep in mind too that they're two separate and distinct processes, if you will. The approval to actually construct and have that facility there is one application and approval process. The granting of the access permit is a separate process. So obviously they may be lockstep to an extent because they're dealing with the same facility, but the access permit is being issued to protect a separate set of rights that facility owner or operator is going to have, i.e. the right to access that facility from an unreasonably or impermissible interfered way.
Okay, great. We had a couple of comments about posting the materials prior to this webinar. Obviously, we cannot go back and do that. In hindsight, we should have, and I'll take full responsibility for that because we are dealing with an area of the law that is very, very highly regulated by state statute and administrative code. And so it would have been helpful to the participants to have that in front of you. And for that, I apologize not having it in front of you. Nonetheless, the materials will be posted to WCA's website, www.wicounties.org, and you can download the presentation off of that website. If you have questions following your review of the materials or your further consideration of what we discussed this morning, please reach out to the Wisconsin Counties Association or me, Rebecca, or Ben. Our information can be found at www.vonbriesen.com, and we will do our best to get information to you. And so, as you might imagine, this topic in many ways reminds me of CAFO or large livestock regulation, but it doesn't, because while it reminds me of CAFO and large livestock regulation in that there are discernible state standards and counties cannot go beyond that, the process as it relates to approving siting for wind energy and solar energy systems is much different than the approval process that we've got for CAFO and large livestock. Similarly, it reminds me in a certain way of shoreland zoning, since we've had Act 55, where essentially we said that counties do not have the ability to adopt shoreline code standards that are more restrictive than the NR 115 standards. But it's different because the approval process and the local authority retained is different. And so I think our hope at some point is that there is some sort of consistency across the board as it relates to land use decisions and a county's authority to regulate land use and operations and siting and construction and things like that. But I don't know that that's going to happen anytime real soon. So the best that we can do is have a solid understanding of the extent of a county's jurisdictional authority as it relates to these various land use decisions, and then apply the standards that are contained within state statute and administrative code to that particular area. Understanding too that it's not one size fits all. I wish it was as simple as, oh, we have a wind energy siting application, therefore we do X, Y, and Z. We have to go case by case, and then we have to understand exactly what standards apply and which ones don't apply. Likewise, even when it comes to building out an ordinance, we have to have a solid understanding of what the areas within PSC 128 are that say these exist only if we have a county ordinance on the book. So I think even the initial decision about what should we put into a county ordinance can become complicated. So all of this is just a very long-winded way of saying work extensively with your zoning and planning staff, work extensively with your corporation counsel and others to make sure that from a legal standpoint and a planning and zoning standpoint, you're doing the best you can to regulate within the boundaries of, from a policy perspective, you want to regulate. And then don't be afraid to reach out to your neighbors, have discussion with corporation counsel and others in counties around you and from around the state and see what it is that they've determined to be best practices. And then as well, feel free to reach out to the Counties Association or to us to ask questions and see if there are other thoughts out there about what can or cannot be done. So before I conclude, let me ask Rebecca and Ben, any final comments that you want to make today?
I do have one final comment. This statute also reminds me of cell tower siting. And like cell tower siting, I think it is so important to remember the timing deadlines, because from your county's perspective, you don't want to fail to act within a certain period of time under these periods of restriction, and then have something be deemed approved. I unfortunately have seen that happen. We have one county right now that's facing that deadline within a matter of days. And while an owner can agree to extend those statutory timelines, as a county, you don't want to be behind the 8 ball, and you don't want to be within the discretion of that applicant. So just pay very close attention to those statutory timelines that impose the restrictions on when you have to act.
Ben, any final thoughts?
Nope, nothing for me.
Great. And with that, then I will thank everybody for your participation today. Again, this is an interesting topic. It's somewhat complicated and it can be difficult to wade through, but hopefully the takeaway from this webinar is that we all have an understanding as to the foundation and the options. And now we go about the hard work of trying to make sure that our existing ordinances and code comply with state statute and administrative code, and that to the extent we need to update or modify, we know the process for doing so and what the limitations are in that process. So I'll thank you again for joining us this morning. Have a wonderful Monday and good luck as you go through this process. Thank you.